going to do the lovely screen share, which always turns into one of these "can you see my screen" efforts. So I think that should now be on your screen. Can you see that, Sharon?
Yep, I can see that.
I don't know if you can still see me, but if not, then that's fine. I will put my face back up at the end so that you can all see me. Cool, so I'll just get right into it. Basically, I was asked to come along tonight just to give you guys a bit of an overview about what the law says in Scotland. So that's basically what I'm going to do, and I'm going to try and keep it quite short so that you can ask questions at the end, because it can be quite boring listening to me talk about the law for ages, and it's probably better for you guys to just ask me questions that apply to you, and I can sort of hopefully give you those answers tonight. So basically the way I've set it up is we're going to navigate what the legal world is about becoming parents in a modern family. So to give you a bit of a background, I'm a senior solicitor within BTO. We have offices in Glasgow and Edinburgh, and we service the whole of Scotland. We're a very big firm and we do everything, but we have a very specialist family team, and I've been in that family team ever since I was a trainee, which has made me a specialised divorce family lawyer. So for about half the time I do divorces and child cases and prenups and all that good stuff. And then on the other half, I run our modern families practice, which is something that I developed for the firm, which basically specialises in what I call modern families. And my definition of a modern family is anyone who's not in a non-nuclear family model. So for us, that's obviously our LGBT base alongside our single parents, blended families, and families that have more than one family unit in it. So co-parents and families that are trying to navigate co-parenting separately. So in terms of trying to give you a bit of background into why I do this, I thought it would be good to just give you a tiny bit of background about myself. I've always felt really passionately about making the law equal for modern families, hence why I brought this basis of work into BTO in Scotland. There's very little of us that do this work in Scotland, and quite a lot of what we do is about trying to push for change in the law as well. I'm in a modern family myself. I live with my partner Tina and our dog Finn, who probably gets treated just the same as a child. So I completely and wholeheartedly understand the difficulties and barriers that the law has for my clients and what they face on a day-to-day basis. So tonight, what I'm going to talk about is what the law says in really general terms. And everyone in this group will know there's no way for me to talk about the law that will apply to every single family unit, because everyone's different and everyone's going through a different journey. So I will talk about what the law generally says, and hopefully the presentation itself will only be about 20-30 minutes, and then you guys can ask me loads of questions at the end. However, these things and this topic is highly sensitive, and so you might not actually want to ask many questions in the group, and that's absolutely fine. And I'm absolutely more than happy to answer questions privately. So what I've done is I've left my email and my phone number on the end of the presentation, and Sharon will send that out to you guys. And if you do have any questions you want to ask but just not in the group, then just send me an email or give me a call, and I'm more than happy to have a chat with you in confidence about that. So my plan tonight is to cover the general law of conception for same-sex female couples, the general law of conception for same-sex male couples, some additional considerations for a couple or a single person that has a transgender parent in it, some other things you might not have thought about from a legal perspective that apply to everybody, and then we'll finish up with a Q&A at the end. So before we get into the nitty-gritty of exactly what happens to each couple, I thought it might be helpful to first of all consider the question, why do you need to know what the law says anyway? Because for certain types of couples, the process of deciding to have a child is more straightforward than for others, biologically speaking. So sometimes, depending on your situation, you might not even think to check with a solicitor about what the legal position is, because you could quite easily just assume that the law just automatically protects you should something happen further down the line. In my opinion, it should do that, but unfortunately, the law doesn't do that for you most of the time if you are in a modern family unit. So you just need to be careful that you are taking all the right steps along the way to keep yourselves right. The reason for this is because most of the law that governs family life was written yonks ago in the 80s, when leg warmers were still perfectly acceptable fashion. So with that in mind, you can imagine in the 80s it was written with the nuclear family model in mind, and so it only gives legal protection to certain types of people within certain types of families in certain situations. So that has changed a bit over the years, with different patches of legislation providing additional rights to certain types of people. So if you think like the Same-Sex Marriage Act and the Human Fertilisation Embryology Acts, they've all come in and patched up different bits of the law to help give better rights to more people. However, what that's effectively done is make the law as a whole a bit of a patchwork blanket, with different bits applying to different families, sometimes more than one bit applying to the same family at the same time. So it's so important that if you have any concerns about that you check in with a solicitor beforehand, or your clinic, who can make sure that you're keeping yourself right and making sure that you're doing everything that you can to still be on the right path. So one thing that is important to understand and learn about is parental rights and responsibilities. That is the long and fancy term that us lawyers use for basically being an active parent in Scotland. You'll hear me talk a lot about parental rights and responsibilities, or PR&Rs, a lot through the presentation, because that's essentially the bedrock of what we want all of you to get at the end of your fertility journey. Parental rights include things such as the right to have direct contact with your child or to have them living with you, the right to be involved in major decisions about that child's life, such as where they go to school and whether they should undergo certain medical treatments. Parental responsibilities include things like the responsibility to safeguard the welfare of your child, or the obligation to financially support that child with child maintenance. Now, importantly, you can only have 2 legal parents for a child, but more than 2 people can have parental rights and responsibilities for a child. You can have certain parental rights and responsibilities, and you can have certain parental rights and responsibilities removed by a court. So for example, a court can give a sperm donor under certain conditions the parental right to have contact with a child, depending on certain conditions, but leave off all the rest. So that's how it works, and why you need to understand that concept for some of the stuff I'm maybe going to have a chat about later. Being the legal parent of a child is a different thing, and there can only ever be 2 legal parents for one child at once. Being the legal parent will automatically give you the full raft of PR&Rs. And for some families, we need to take some extra legal steps, either at the conception of the child or on that child's birth, to make sure that both parents have a full complement of PR&Rs in respect to that child, just to make sure that they both have equal rights and responsibilities for that child that they've helped to bring into the world. So the last consideration that we have to bear in mind as we talk through this stuff tonight is that although at this stage we're talking about making babies, these babies only stay babies for very short periods of time. What we're really talking about is we're creating adult people. And so sometimes there's some extra considerations to think about that will follow that child into their adult life, and what makes it really important that you take all the right steps now for them. And a really good example of that is succession law. So if something were to happen to you later in life, that child needs PR&Rs and needs to be your legal child for them to be able to inherit. Additionally, if you're using a donor to have a donor-conceived child, there's certain rights for that child to access information about that donor as they get older. And so it's important to have a think about all of that right at the start. So that's a bit of an overview of the things we'll talk about tonight, and the important legal terms that you might want to know when we're talking about the rest of the stuff. So the first thing that I'm going to talk about is what the law is for female same-sex couples. And what I've done here is I've written down sort of roughly what the main things are that female same-sex couples come to me about. So the first one, and I'll speak about this in detail tonight, is donor conception. So that one's definitely the most common form of family building for female same-sex couples. So that involves the use of a sperm donor, and there's different types of using a sperm donor, and we'll go through this tonight. The other one's co-parenting, which is where you have a child with a man who's it's intended will be involved in that child's life. So not a sperm donor, somebody who you have agreed that you're going to have a platonic child with. And then the last one of that is we get inquiries about adoption, which is another common form of family building. However, we're not going to be discussing that one in any particular detail tonight. We'll also talk about options for male same-sex couples, and I'll talk through all of these, and some of these can also apply to same-sex female couples or individual parents. such as surrogacy, but I'm going to talk about it in the context of male same-sex couples tonight, but the rules are all the same. So surrogacy is the most common form of family building for male same-sex couples. So we'll talk a little bit about surrogacy. Again, co-parenting is the exact same, just flip reverse, where you have a child with a woman who it's intended will be involved in the child's life. And then adoption, again, another common form, but we won't be talking about that in any detail tonight. So the first one we'll talk about then is donor conception. So what I'm going to do is talk about donor conception only in the context of being used by a female same-sex couple. But of course, there are similar considerations if you are in a male same-sex couple and you're using a surrogate. Some of this will also apply to that if that surrogate or is an egg donor or you're using a separate egg donor in your journey. So the first consideration is whether you're using an unknown sperm donor or unknown sperm donor. And what I mean by an unknown donor, because as Sharon will tell you, there's no such thing as a completely unknown anonymous donor anymore. But if you're using an unknown donor, what that means is that you're using sperm that you've received through treatment in a clinic. So sometimes this can be imported or purchased from sperm banks either abroad or within the UK. However, this is the most straightforward legal route if that is the situation you're in. And the reason for that is using a donor that has been assessed by a clinic provides you with legal protections in respect to that resultant child. The donor is screened by the clinic, so you'll also have to go through some hoops that are prescribed by the clinic in terms of consent forms, paperwork, things like that will make you go through on the legal side. However, the benefit to this is that once you've gone through all those hoops, you do benefit from legal protection in the forms that you sign with the clinic. That will make both of you the child's legal parents and will furnish you with the whole raft of parental rights and responsibilities. This is also the legal process that will extinguish any would-be PR&Rs of that sperm donor. A donor who's donated through a clinic has no right to apply to the court for contact with that child or any information about that child if the child doesn't contact them. So that completely extinguishes that person's role in the child's life. There are other considerations we'll come back to about using a known donor, but that is why it's the most safest legal route to use if you are using a donor. However, unknown donation isn't for everyone. Sometimes, and I'm sure Sharon's already spoke to you about this, but sometimes people feel like there's a lack of options within the sperm banks or lack of options with the type of donor that you're looking for through the sperm banks, which over recent years has increased the number of people that look to use a known donor. So that's where a known donor is where it's using somebody that you know, somebody sometimes you have a relationship with, or sometimes that's somebody that you've met online or through a group or something like that. So the law is a little more complex if you're using a known donor. If you're a known donor and you're donating to a married couple or a couple that's in a civil partnership, then the legal parents will be that couple. You benefit from that legal protection there. However, there are other considerations you want to take into account that aren't just straightforward what the law says, of course. The difference is, however, if you use a known donor, that known donor can ask the court's permission to apply to have what we call Section 11 orders granted, which are orders in respect of the care of a child. The way that you have automatic PR&Rs is that you could apply for Section 11 orders at any point. However, sperm donors that have used a known donor in that scenario can apply to the court for permission to apply. They have to jump that hurdle of showing the court that there's a reason why they should be having contact, and a lot of that will depend on the circumstances around that child's life. So if you had, for example, used a known donor and then the first couple of years of the child's life you had let that donor have contact and they'd built a relationship with that child, if you then took that away because there had been a falling out, that sperm donor can ask the court's permission to apply to have rights for contact because it's already been established. If the court agrees with them, lets them in, that doesn't necessarily mean they'll be successful, but they will have that opportunity to ask the court for it, which will then all depend on the certain circumstances of the case. So that's why it's really important that even if you do benefit from that protection, so let's say you're in a married couple and you're using a known donor, which makes you the legal parents of that child, it's so important that you very clearly have a conversation and multiple conversations with that donor to make sure that the expectations for everyone are really clear. That is number one from my experience, the most important thing that you can do to try and avoid any potential mishaps further down the line. If you're using a known donor and you're not married or in a civil partnership, then that sperm donor will be the child's second legal parent. That means that they will be furnished with the automatic suite of parental rights and responsibilities. And so you have to be so careful in that scenario to go through a clinic. We would never recommend that you do that if you don't already benefit from that legal protection. And again, you can run into hurdles there if expectations aren't clear. But don't get me wrong, using a clinic's not for everyone. And in that scenario, we have successfully helped a lot of couples put together known donor agreements to outline what's been agreed and to make sure everyone has considered what they want to do. These agreements aren't legally enforceable, however, they are good at setting out intentions and showing what's been agreed. The top tip that I have for it is if you're using a known donor, it is so important to discuss all of your expectations in great detail and make sure that you're all happy to do that. And if you possibly can, go through a clinic, because that will provide you with that extra level of reassurance and legal protection for that person to be registered as a sperm donor and for you to benefit from that legal protection there. And then the last thing to bear in mind from a legal perspective, if you are going down the route of donor conception, is that there is no truly anonymous donation anymore. Children are entitled to certain information about their donor when they turn 18. And it's especially important to consider the advent of DNA testing companies, which are becoming much more frequent nowadays. So you'll all have heard of the likes of 23andMe, heritage.com, all those sort of things where you can buy a £79 DNA test. And if you are using donor conception, it's a good idea to go and have a research about what the lives of donor conceived adults are like, because for a lot of them, they will look to find out their genetic heritage after they are able to do that. And so sometimes having more information about your donor from the get-go is actually a much easier way to deal with that. So that's all the important stuff that you need to know in terms of what the law says about using a donor, but you can ask me any specific questions about that at the end. So the second thing that we'll talk about, which mostly applies to same-sex male couples, however, can apply to lots of different types of families, and that's surrogacy. So there's two main types of surrogacy that you should be aware of, and that's surrogacy in the UK and surrogacy abroad, or sometimes known as international surrogacy. So the main bits of the law to be aware of for surrogacy are that it's only altruistic surrogacy that is legal in the UK, and that's a fancy word for being not paid. So you can't make any commercial payments to a surrogate, and it can only be done from goodwill and on the basis of the surrogate being paid some reasonable expenses. So reasonable expenses are pretty vague in our law. However, it generally means within the realms of the tested cases are about 15 to 30,000, the sort of max that will be authorised by a UK court at the moment. Surrogacy obviously is where a completely separate third party independent person agrees to carry the child for the couple or for the single person, and you can either have gestational surrogacy or traditional surrogacy. Traditional surrogacy is when the surrogate is also the egg donor, and gestational surrogacy is when it is the egg and sperm used by potentially a second donor or the couple undergoing the treatment to create an embryo that's then implanted into the surrogate. The law in the UK is exactly the same regardless of the type of surrogacy you've used, and the law says that the person who gives birth to the child will be considered to be that child's legal mother. So that one's relatively straightforward. The surrogate will always be considered to be the child's legal mother. Who the second legal parent is will depend on a couple of things. The first one is whether the surrogate's married or in a civil partnership. If she is, then her spouse or civil partner will be the child's second legal parent. If she's not married or in a civil partnership, which is most common in a lot of cases, then the legal parent can be the intended parent who donated sperm to that arrangement, if you can show that that's the case. So sometimes a DNA test is required to do that. So what happens once a surrogacy arrangement has been signed up to and you have gone through the process? You would then have to apply for a parental order at the end to change the child's legal parents to the intended parents. So there's a number of conditions that you have to meet to have that granted, including some basic things like having an age of 18 and living in Scotland when you do that. but it also requires you to not have paid any more than reasonable expenses for it. So again, that's why it's important that you get some legal advice about that and make sure that you're within the realms of what is a reasonable expense. On top of that, you have to have the child living with you in the UK. So if you have gone abroad for a surrogacy arrangement, you have to have the child back in the UK when you make your application. So sometimes you can run into problems with that abroad if you can't get a passport or if you can't get citizenship. And obviously right now with COVID, there's even more considerations to bear in mind for that. That's where we can also help though if you do run into problems with that, because we can lobby foreign governments and embassies to help get baby back into Scotland for you. But assuming that all the conditions are met and that baby's here and that we're all sorted and ready to apply for the parental order, then that's done by applying to your local sheriff court in Scotland with a petition for a parental order. That involves you writing out a court action that explains to the court that you've been in a surrogacy arrangement and that you're wanting to change the legal parenthood from the surrogate and her partner, if she has one, to the intended parents. It is relatively straightforward, and I always say to my clients that it's actually the most positive court experience that you'll ever have. The sheriffs are very friendly in that respect, and I have been at cases before where the sheriffs actually asked me to ask the clients to bring baby in so that he can give them a little speech about how their life's changing and how they were so dearly wanted. So it is a really positive experience, but it can be quite tricky. So sometimes, and in that scenario, I would always suggest that you contact a solicitor to just double check that you're keeping yourself right, and they can also help you with the application if you need to. So that's a bit of an overview of what the law says about surrogacy. Obviously, surrogacy is a very complex area, and I can only give you a brief overview in a context like this. But if you do have any questions about surrogacy, then just let me know. And if you're watching this on the recording, just drop me a wee email. I'm happy to answer any questions that you have about it. So then the last one to touch on is co-parenting, which sometimes will happen. The most common set of clients that come to me about it are a female same-sex couple and a male same-sex couple who have decided that they would rather have a child together than use donors from either side. So it's a platonic way, but they've decided that they want to have that child together. So the number one question I always get asked is co-parenting legal? Is that a thing? But it actually is quite a common thing. And yeah, it is completely legal. The thing that you need to bear in mind if you are considering going down the co-parenting line is, again, the same thing about donor conception. It is absolutely essential that you have counselling and that you have a lot of talk and a lot of discussion about expectations. What we expect, who's going to do what, and what's going to happen if something goes wrong down the line. To do that, we would suggest that you enter into a co-parenting agreement, which is where you sit down, have a discussion, and you can draft one up yourself if you guys are happy with that, or you can instruct a solicitor to do that for you. Again, they're not legally binding, but they go a long way to showing intention, so that if there ever was a dispute further down the line, you've got a very clear record about what was agreed and what was not agreed. So the main thing is to consider with that is, what if something goes wrong? A child, like I said earlier, could only have two legal parents, and that remains the case for co-parenting. However, you can have parental rights and responsibilities for a child, even if you're not that child's legal parent. So in that scenario, you could have rights to contact, you could have rights to have that child live with you if that's in the child's best interests. But this would normally only come out in the event of a dispute. So let's say one of the couples separated in that scenario, and then one of them who wasn't the legal parent wanted to seek contact. That's perfectly allowable. That person would just need to apply first to have parental rights and responsibilities granted to them, which, given the context of that, would generally be acceptable. There's not been any cases in Scotland about this yet, which is a good thing, because it's only in disputes that they end up in court. But there have been cases in England that are likely to be followed in the Scottish courts because it is a UK-wide law. So if you are thinking about going down that route, I would definitely advise that you have a chat about that in your group and then also with a solicitor, just to keep yourself right. So there's a couple of additional considerations that I wanted to bring up if you have a couple or an individual person who's a transgender parent, just that makes it a little different from what the law already says. There's not an awful lot that's different. Again, you would just have to rely on certain types of the legislation to get it through. Some of it is slightly different. But again, we can give you advice about that if you have any particular questions in that regard. So the first thing that I always get asked about this is what happens to parenthood post-transition. So if you transition after you've already legally got parental rights and responsibilities for a child, So after you transition, you will keep your parental rights and responsibilities and nothing changes in that regard. You will have to keep the pronoun that was used on your original birth certificate for that child. So if you're listed, for example, as a child's legal father, that will stay. There's been a lot of tested cases recently about that. It's not got to the Supreme Court yet, but I highly anticipate that it will be. However, in anticipation for that, what the government has done is they've changed the wording on new birth certificates so that instead of just father, it says father/second parent, and it also says mother/primary parent or birth parent, I think it's called. So they have started to change some of the terminology there, which is good, but I don't think it goes far enough, and I do hope that over the next couple of years we will see that change. That leads me into a bit of our second point, which is relying on your pre-transition legal status. So again, the same legal protection that I've spoken about for donor, conception, surrogacy, etc. is absolutely fine if you are transitioning or you have recently transitioned. And although the terminology, in my opinion, is completely unsatisfactory, they will still allow you to use the provisions of the Act which give you rights under fertility treatment, but you will have to use your pre-transition legal status to do that. So if you are the person who's provided the sperm in that, all the paperwork is listed as you being the child's legal father. However, on the birth certificate itself, it will say second parent. So in terms of the external stuff, the right stuff will be on it that we need, or as close as we can get to the right stuff at the moment. But the underlying paperwork is not as friendly. So that is something that I always point out to my clients to just bear that in mind. And again, for assisted conception, if you are using assisted conception and your partner's carrying the child, you can be noted as a child's second legal parent. So the only one at the moment that's causing us a lot of difficulty in the community is that if you are the person carrying the child, but you have legally transitioned to be a male, it will still say mother on the certificate. There is a case live at the moment in the courts about that, so I can keep you up to date. And if you follow our Twitter and everything, we're keeping up to date with that to see if the law changes on that front. And then the last one is for surrogacy, just to be aware that if you are using a surrogate, the parental order process will still allow you to become the child's legal parent. So that bit where you change into the parental order, that is absolutely fine as it is. So that's the only bit that does us some good at this point. And then finally, I wanted to touch on just some other legal considerations that you maybe didn't think of yet, because I know that when you're at this stage and you're planning, it's all a bit overwhelming and you think, oh my goodness, there's 10 million things to think about, and these are probably not anywhere near the top of anyone's list. But I thought, well, if I'm here, I might as well sort of give you, if I was going through it, what would I be thinking about longer term legally? So the first one is wills, and yes, I know, completely morbid. It is the worst thing to talk about, but it is so important that you should be prepared should something happen to either of you, either during the process, or the one that I always talk to people about, it's a client I've had previously, is that if you are intending to have treatment and you get treatment done to prepare you for that, so let's say you're creating embryos or you're donating sperm or donating eggs for treatment, what would you want to happen with that with your partner if something happened to you? So one of the examples that we've recently had out the court just this year was where it was a heterosexual couple, and they were going through fertility treatment. They had recently made their donations of egg and sperm to have those created into embryos for the wife to then carry that pregnancy. Now, the husband then became very ill with meningitis very quickly after that happened, and then lost capacity very quickly to be able to sign any consent forms about that. So the authority said that they couldn't treat them, and she wanted to use his sperm sample after he passed away to have a child, because that's what they had wanted to happen. The authority wouldn't give their consent for that to happen at the clinic because they said that the consent wasn't validly signed. However, he had left a will that made a very clear, specific provision about what he wanted to happen with his donated sperm should something happen to him. And because the wording was really specific and it said on it, I want her to be able to use the sperm for any treatment, even after I've passed away, that the court gave the green tick for her to be able to use it. So it does just show that it is important, if you're going through any form of fertility treatment right at the start, to just update your wills, make sure it's got everything in it, and that'll keep you right should just the absolute worst happen. But touch wood that wouldn't be the case. Sort of linked to that again is ownership of gametes and embryos. So again, it's important to give the clinic all of the consents that they might need in terms of dealing with any stored embryos or gametes. So the clinic will have consent forms about all of this stuff. So just make sure you ask them about that if it's not offered to you, and also have a discussion with your partner about, well, what would you want to happen if something happened to me? Would you want to still use those, you know, if we made embryos, would you still want to use them? And what happens if we store them and we split up at a later point? What would we want to happen? Just having those conversations and making sure that your intentions are really clearly noted will keep you on the right side of things and make it just a lot easier for you if something were to happen. And then the third horseman of the apocalypse of awful things I'm talking about now is separation. And obviously I deal with this in the other side of what I do for work during the day. And it's never ever nice to think about what might happen if you did split up further down the line. But it is important to make sure, and I'm sure everyone on this call has the same mindset to this that I do, but you're in a position now where you love each other and that you're taking these important steps together, and you want to make an agreement now that should something happen down the line where you split up, you want to treat each other with enough respect, and you know, respect as that potential child's other parent, and to make sure that you've taken all the steps that you need now to have PR&Rs, so that if you did separate, you would both be on an equal footing in terms of that child, regardless of biological makeup. I've had a lot of particularly same-sex female couples come to me at the wrong side of a separation, where they've realised they didn't take the right steps in the first instance to get the non-birth parent the right parental rights and responsibilities, then meaning that that parent was then forced into court to have that granted before she could ask for contact with that child. And even given the time it takes to do that, which is a couple of months, you know, even going that long without seeing a child that you've had a relationship with the whole life that is your child, is gut-wrenching. So it is important to think about that stuff at the start and make sure that legally you're both on an equal footing on that regard. And then the last thing that I've talked about a couple of times now, can't emphasize it enough, is expectations. Expectations, expectations, expectations. Talk everything through. We love to talk. Everyone loves to talk. And so the more talking you can do, the better, and the smoother it'll make it if, God forbid, something was to happen further down the line. Especially if you're using a third party in that, if you're using a known donor or your surrogate, it's so important to build a relationship with that person and make sure you're really comfortable with that position, because whether you like it or not, the second that a third party becomes involved in that, even just from a biological perspective, there is a likelihood, if you look up what donor conceived adults are now like as adults, they will want to know more information about them most of the time. So it's important that you're comfortable and being able to have those discussions with them and explain it to them, and that you're comfortable with that choice you've made. So it's about taking a long-term view and thinking ahead and making the road as easy as possible for you guys, so that you can focus on the important thing, and that's becoming parents in the first place. So using the likes of us and Fertility Network and the clinics and the counsellors, let them take away all of the other stuff so that you can focus on the actual nice part, which is becoming parents. And what I always say to my clients is that, especially in the LGBT group, is that I always find that it's amazing that it's not biologically possible for anyone in this group to accidentally have a child. So every child that's in our group and every child we deal with at B2 in this scenario has been desperately wanted, really fought for, and you've had to jump through a lot of hoops to get there. So bearing that in mind and just being extra careful to make sure that we're keeping that up and that we're doing everything right is the best way to go. It's a nice thing to think about. So, and with that, that should be our Q&A open.
Oh, thanks very much, Beverley. That was brilliant and really informative. I'm going to stop the recording now.